The Supreme Court just turned its back on you, me, and every gun owner out there. And yeah, the whole community is pissed. This might be one of the biggest gut punches to the Second Amendment we've seen in years, and it's coming from a court that's supposed to be pro-2A. In this video, we'll talk about what just happened with this case out of New York, why the court's refusal to intervene is alarming for the entire country, and how anti-gun states could use this as a blueprint to crush our freedoms. For some quick background, this all comes down to a lawsuit known as Antoniuk v. James, which centers on the Concealed Carry Improvement Act that New York rushed into law right after the 2022 decision in New York State Rifle and Pistol Association v. Bruen. In that earlier ruling, the Supreme Court basically said, no, you don't have to show a special reason just to carry a handgun. The Second Amendment itself is reason enough. That was a major victory for those of us who believe in the right to defend ourselves. But in response, New York sprang into action. Rather than accept defeat, lawmakers hammered out a new set of permit rules designed to punish ordinary people who want to exercise their right to carry. These new rules were so extreme that many experts saw them as a direct middle finger to the court's ruling. The new law wasn't just about removing a single barrier, it slammed down multiple roadblocks. First, it introduced a demand that concealed carry applicants provide the government with a list of their social media accounts so officials could sniff around for anything they disliked. Second, it forced people to reveal every adult or minor living under their roof, possibly so officials could contact them and dig up more reasons to deny a permit. Third, it flipped the usual rules for places like private businesses, stating that gun owners could not carry unless the business posted a special sign granting permission. Then, as if that weren't enough, it broadened the so-called sensitive places category to include parks, zoos, protest gatherings, and treatment centers, in addition to bars and restaurants serving alcohol. It was the ultimate attempt to dodge the fact that the Bruen ruling wiped out New York's old proper cause scheme. Gun owners didn't take this lying down. Folks like Ivan Antoniuk and several gun rights groups stepped up saying, no way, this is clearly unconstitutional. It kicked off a fierce legal fight, with the case moving through trial courts and then landing at the Second Circuit Court of Appeals. Hopes were high that the Supreme Court would step in quickly, squash these new restrictions, and remind New York that the Constitution cannot be sidestepped. Instead, the Supreme Court chose not to hear the challenge at this stage. That decision, failing to act, means the Second Circuit's ruling stays in place, leaving huge sections of this law active for the time being. A lot of people wonder, but doesn't the Supreme Court's silence mean they actually agree with New York? In theory, no. Declining to hear a case doesn't necessarily confirm agreement. The justices might have a variety of procedural reasons. However, in the real world, it puts a big stamp of approval on what the lower court did, at least in the eyes of other states looking to push similar restrictions. When the highest court steps aside and refuses to intervene, it sends an unfortunate signal that the lower courts can keep enforcing these restrictions unless and until the Supreme Court decides to resolve them later. We're left with several major consequences. First and foremost, the state of New York now holds on to its newly minted system that forces you to jump through additional hoops if you want to carry a gun. That means turning over all sorts of information that goes beyond a standard background check. Next, anti-gun states are celebrating. They see this as a roadmap to pass their own expansions of sensitive places and morality tests. The refusal to hear the case now might embolden places like California, New Jersey, or Massachusetts, which could roll out the same invasive strategies. If a handful of states do that, we'll be dealing with a bigger, more tangled fight down the line. Now, not every part of New York's law was rubber-stamped. There were a couple of tiny glimmers of hope. For instance, courts said the state can't force you to give them your entire social media history, but that was shot down mostly on First Amendment grounds, not because the judges recognized the significance of the Second Amendment. The requirement basically forced people to reveal anonymous or pseudonymous accounts that could be used for free speech. The fear was that it would chill political debate or allow officials to punish you for personal views. That is a relief. But it also underlines how the Second Amendment wasn't the deciding factor in that particular piece of the legal puzzle. Another part that didn't survive was the idea that all private businesses must be gun-free unless they hang up a sign that says otherwise. A court saw that as going too far. Think about how insane that requirement would be. Instead of presuming property owners have the right to say, no guns, It flipped the assumption so that almost everywhere was automatically off-limits, unless the owner put up a sign inviting armed patrons inside. That idea raised more legal eyebrows, but again, that got thrown out largely on grounds that also touched on property rights and broad overreach, rather than a strong affirmation of the right to carry. We're still left with the major pieces that are deeply troubling. Judges allowed New York's so-called good moral character requirement to stand, meaning that if you want to carry, you now have to prove you're of solid character, temperament, and judgment. How do you prove something that intangible? Who decides if you're good enough to exercise your constitutional right? Critics of this approach call it a sneaky method to restore the old May issue system under a new name. Instead of requiring you to show proper cause, they're effectively requiring you to show that you meet some arbitrary moral standard. That is a massive shift in the burden of proof, and it opens the door to all kinds of subjective denials, depending on the viewpoint of the licensing official. On top of that, the court upheld a catch-all provision, allowing officials to demand just about any extra information they think is relevant. With such an open-ended rule, the local licensing authorities have nearly unlimited power to snoop. Maybe they'll comb through your financial records, your personal relationships, or your credit card purchases. There's no guaranteed safeguard to stop them from abusing that power if they have political reasons to shut you down. They also kept in place a sprawling sensitive places ban that forbids you from carrying in an ever-growing list of venues, including parks and zoos, plus locations where alcohol is served or where First Amendment gatherings are taking place. Many of us find that last one extremely unsettling. Are we supposed to believe that free speech rallies, protests, and houses of worship should be stripped of Second Amendment protections? Part of the Bruen ruling had stressed that schools, legislative buildings, and courtrooms are historically recognized as sensitive places, but apparently the new push is to label half the state off-limits. This is exactly the slope so many warned about. The Bruen decision gave a clear command. If a modern-day gun restriction is historically consistent with laws from the founding era, it might pass. Otherwise, it likely violates our rights. Yet what the Second Circuit did was look at only 2 or 3 partial regulations from the 1800s, laws that were vague or rarely enforced, and then use them as permission to let modern states treat large portions of public and private spaces as if they're gun-free. In Bruen, we had a statement that a handful of laws can't rewrite the meaning of the Second Amendment, but here we see courts effectively ignoring that. And with the Supreme Court ducking the issue, it leaves the impression that small pockets of old legal text might be enough to shut down the right to carry in wide areas. It's not an overstatement to say that the big fear is, if 2 or 3 century-old statutes can be used this broadly, what stops states from dredging up anything from that time period, no matter how obscure, and claiming it justifies a brand new wave of restrictions? Because the Supreme Court decided not to take this on, at least for now, those states have a green light to keep experimenting. We could see a chain reaction where each anti-gun legislature references any tiny fragment of local history to justify a broad ban. Some folks might be thinking, wow, well, maybe the Supreme Court will step in later. That's possible. This isn't the final word on Antonyuk versus James. The door remains open for more specific or narrower lawsuits. Gun rights organizations are likely to bring new challenges, focusing on small parts of the law one at a time. There's talk about religious institutions fighting for their rights, bars and restaurants that see themselves singled out, or individuals who've been denied under the good moral character clause without any valid reason. Each of those fights could reach the higher courts, eventually wearing down this law piece by piece. But that's a slog. It means more time, more legal fees, and more unpredictability for those who want to lawfully carry and protect themselves. The unfortunate reality is that big, clean wins in one giant lawsuit, like the original Bruen case, don't always happen. Sometimes we're forced into death by 1,000 cuts in reverse. Instead of anti-gunners picking us apart, we have to pick apart their laws. While that can still work, it's a much slower, more frustrating road. Meanwhile, the law remains in effect, making a lot of people choose between compliance and the real possibility of felony charges. There's a deeper frustration here, too. The Supreme Court's own language in Bruen seemed clear that a right to carry is just that, a right, not a privilege that officials can dole out based on moral evaluations. Many supporters of the Second Amendment feel that this new requirement in New York is a direct contradiction of what Bruen was all about. The question is why the justices would allow a lower court to interpret the ruling in a way that basically guts it. Maybe it's a procedural technicality, or maybe the court wants more lower courts to rule differently before it steps in. Either way, ordinary law-abiding people are stuck in legal limbo. The emotional punch can't be ignored. This is the second time in less than a year that New York has turned around and slapped defiance in the face of gun owners right after a Supreme Court directive. If you think about it, the state lost in Bruen, then quickly wrote a law that's arguably more extreme than the one that got struck down. Some might see that as a test of how far New York can push things. And at the moment, it seems they can push them pretty far without immediate consequences from the nation's highest court. That's the climate we're dealing with. Meanwhile, other states are piling on. New Jersey and California have been brewing their own laws that expand sensitive places to cover beaches, stadiums, public gatherings, you name it. These states already have a history of restricting carry permits. With the Supreme Court's passing on Antonyuk at this juncture, we're almost guaranteed to see more of it. None of this means we should just pack up and admit defeat. Far from it. Multiple Pro-2A legal groups are preparing the next wave of lawsuits. They know it's now an uphill battle, but one worth fighting. We still have the foundation of Bruen itself, which said public carry is a fundamental right not to be rationed away. And we can still rely on a strong self-defense tradition that goes all the way back to the founding. The difference is that we'll have to proceed step by step rather than expecting the Supreme Court to slam the door on New York's law all at once. But that begs the question, what do you think anti-gun states are going to pull now that SCOTUS just looked the other way? And how do you see this shaping the gun laws where you live? Drop your thoughts in the comments, and while you're here, hit like, share this with fellow gun owners, subscribe, and ring the bell so you don't miss what's coming next. Thanks for watching.